CRPC or the CPC with the cyber law interaction. Time is short, so perhaps we can have another webinar on these issues. You will have a lot of opportunity to deal with the crimes and the interactions and the difficulties which children especially will face in what are covered within the meaning and ambit of cyber laws. Especially in the context of the post-COVID 2019 situation and the current social distancing norms, the thrust on everything relating to the internet is way beyond what any of us had ever imagined. And the result is that you see extensive, virtual crimes being committed, be it in financial matters, be it in on sexual violence areas. The whole definition of violence is changing. The whole imagination and the manner in which we will look at individual acts in the context of penal offences has to change. There will be many acts which may not be covered under specific offences, which will require a lot of judicial interpretation and legal innovation. You have to imagine those situations and give full air to your proactiveness in evolving appropriate conclusions to bring actions which are which though not covered under specific penal provisions but could be brought under the definitions of different offences, and discuss wherever you have doubts. Discuss also where you think there are legal vacuums which need to be filled with the legislation. All of you from different parts of Jammu and Kashmir as well as Ladakh have such a varied experience also of armed conflicts and violence, and also the impact of the availability of cyber facilities to criminals who use these extensively, either for establishing contact or from or for the purpose of executing criminal intentions. So here is your chance to clear all your doubts, especially in the context of the procedural difficulties which investigators face, as well as courts, in drawing links to complete conspiracies, in evaluating and assessing particular conduct. So I'm sure you're going to have a very productive morning, and be prepared for a host of very intelligent questions, because we have some of the brightest judges in the country in our judiciary who have just not been given an opportunity so far for opportunity or exposure so far. So this is their first interface with leading experts. You have come earlier, but I think that time we addressed, trainee judges, if I'm not mistaken. It was a smaller group when you came with Pavan Dugal, but we hope to keep this exchange going and join you in our future deliberations as well. And thank you for your time. I know you're very busy. You're doing a webinar a day, and good luck in your work. So to all my participants, I follow very keenly what have been your observations. Unfortunately, the video is not connecting, and I'm in the middle of a very important court hearing which has been going on for the last week. We have lawyers from Jammu and Srinagar in a bunch of 16 appeals, appeals from 16 orders in writ petitions. So I cannot, Kanika, be with you the whole morning, but perhaps my hearing will close early and I'll be able to join a little later in the day. So over to you, Rajiv. Very good morning to all of you again.
Thank you so much, ma'am. It's an honor and a privilege that you're here to address this gathering today, and for this wonderful opportunity. You've given us a platform to discuss such an important topic with all the judicial officers. I sincerely
just 1 minute. I want all of you to know that Kadika is a very bright young lawyer as well. He's married to one of the best lawyers. I've had opportunity to argue before me. But even more important is that both her parents are very senior lawyers in Delhi. And those of you who are curious should go back and read the famous judgment in Indra Sani versus Union of India. It is a case relating to the Mandal Commission, and the whole gamut of reservation is premised on the judgment. It was the PIL which her mother initiated. Kanika's brother is also a young lawyer in Delhi, and she is one amongst a family of very bright lawyers. So please carry on, Karnika. I must close. Leave you to for my hearing. Thank you.
It's a pleasure. Thank you so much, ma'am, and thank you, Rajiv ji, also for taking this initiative.
Just a minute, Rajiv, I want to say something.
Yes.
Rajiv.
Yes, ma'am. Ma'am, thank you very much. Ma'am, it is because of your efforts that we have been able to get resource persons of such caliber. Earlier also we had interactions with Dr. Karnika and Dr. Pavan Dugal, and it was for the first time that we had interaction with such level of resource persons. Ma'am, thank you very much for your continued support for Judicial Academy. Thank you very much. Now, I would formally welcome Dr. Karnika Seth. Many of us are already uh, having attended one program. I think this was in November 2018. And thereafter, we had few programs on cyber law, cyber security, and appreciation of evidence. But I think the level of understanding which Dr. Karnika would give us is rare to see in other programs. So, not taking too much of your time, Dr. Karnika Seth, I already have forwarded your resume, and all the achievements have been enlisted in that resume. Not all, but most of them, because you have a long list of achievements, and you have conducted many programs across India and in foreign jurisdictions also. So I would not I want this time to be utilized in the deliberations itself. So welcoming again Dr. Karnika Seth. Now I would hand over the deliberations to you. Please, Dr. Karnika.
I express my sincere gratitude for giving me this opportunity to interact with you today on such an important topic. We're going to discuss the IT Act 2000 and the electronic evidence and how the law is evolving in this sphere. And I think is also important from the perspective of increase in cybercrime, especially during COVID and the lockdown times. We are witnessing a lot of rise in cyber crimes, and it's affecting not only adults but also children. So the way I would like to present this session is we will be discussing the IT Act briefly, and then go over to the increase in cybercrime, the kinds of cybercrime we're facing today, and then also discuss the electronic evidence, how we read electronic evidence, and how the appreciation of evidence happens pertaining to matters which are cyber law. So it's a great privilege to be here once again. I'm going to start by sharing the presentation with you. I hope that you can see the full screen. I'm going to do it right away. Are you able to see the screen, please? I hope you can see the screen. So, Rajiv ji, is it okay?
Your screen is on. Content is awaited.
Yes. Great. Okay. Very well. So, the overview of IT Act. I intend discussing the features of the IT Act, Section 43, 43A in particular of IT Act. Apart from the brief overview of the initial chapters of IT Act and the issue of jurisdiction in civil criminal matters, cyber crimes, the IPC and under the IT Act, and some important We start by discussing the IT Act, how it was enacted on 17th of May 2000. India was the 12th nation in the world to adopt laws. And apart from this being the special law, there are a lot of other legislations which also become important in many cases. Specifically, if it's children-related cases, POCSO is usually the act and gets attractive. Otherwise, in criminal cases, IPC sections, procedure code and criminal matters, and obviously Evidence Act is definitely there. It's a general law. Depending on the nature of the matter, sometimes if it is an IPR matter, we have a Copyright Act, a Trademark Act, which may get attracted. And we'll be discussing some of these cases when we discuss the issues. And if it is something to do with any kind of sexual harassment to anybody online, in the representation of Women's Act, if it's a woman, apart from the IPC provisions and the IT Act. Now, when the IT Act was passed, it was passed on the basis of the model law of e-commerce adopted by UNCITRAL in 1996. And at that time, there were these three objectives in the preamble, which are still there. Legal recognition for e-transactions was the main motive of having this, or the intention behind having this act. Facilitation of electronic filing of documents with the government agencies, and to amend certain acts like IPC and Evidence Act. Now, although these threefold objectives are there, but yet do not really completely spell out the main intention and the main purpose, the way the layout of the IT Act is. There are a lot of other aspects to it which are very important in this regard. Now, before I start discussing the main features, this term cyberspace, it has actually, if I reflect back on various authors and writings, there was a book called Neuromancer. It's a science fiction wherein William Gibson had discussed how a cyberspace would be. It would be a space of hackers where even AI-based techniques will flow. And at that point of time, when this book was written in 1980s, we could not have imagined artificial intelligence, yet there was a science fiction, and today it's a reality. So in that background, that when I read section 1 of 2 or 75 of the IT Act, it always takes me back to this book. Reason is this, that in our Indian IT Act, the jurisdiction which is there is very wide. It's a prescriptive jurisdiction which is very wide. I just want to read section 1 of 2. It says that this act extends to whole of India, and save as otherwise, this act, it also applies to any offense or a contravention thereunder committed outside India by. Now, assume for a minute that somebody is sitting in an X country abroad. He commits a hacking attempt on an Indian system or a server or a device, and somebody gets affected. Now, what happens in that scenario is that the person whose system has been hacked, he actually can sue this criminal who may be of any nationality sitting abroad, who has damaged his system or hacked into his data. Now, that is the kind of prescriptive jurisdiction which our Indian IT Act provides. And look at the cyberspace, there is no border, there is just complete expanse, and there is no nationalized territory as such there. And then when you look at section 75, interesting, section 75 also allows you to have that kind of a jurisdiction. And it says that this act will apply to offenses committed out of India also. So, what happens is, in such a scenario, the main, I would say, the act, even if it happens abroad by an Indian national, even that is something which is, actionable. So the section 75 says that subject to provisions of subsection 2, this act applies to any offense or contravention committed outside India also by any person, irrespective of his nationality. So if you see this, irrespective of the nationality of the person, you can actually sue the person. So even if an Indian, for example, goes abroad and he has, committed a crime, you can sue him in India also. That is possible. Because the IT Act says so. So that is the interesting part of the jurisdiction. Now, I also want to, there is another aspect to the IT Act, which is the legal validity and recognition to electronic documents. Now, if you see the electronic documents and the legal recognition, any paper document, which is a hard copy document, will also be something which is, put in a court. Similarly, if it's an electronic document, even that is something which is over. I'll just stop for a minute here. I want the control room to just remove the annotation request, which is shown on the screen here, on the share screen, please. Kindly remove the annotation request by somebody on the screen, please.
Ma'am, you can decline from your side also any annotation request, but I would request all our participants not to annotate on the screen.
Well, I'm trying to do that from my end, but it's not. That's the reason I asked for this. I can reshare the presentation otherwise.
Yes. Ma'am, name of the person would also be reflected on your screen so that
It's
we can.
Rafia Jahangir 2013.
Yes. Mahavir, please avoid annotating on the screen. You would, in the end of this program, you would get this presentation also. Yes, ma'am. Sorry, and you continue, please.
Yeah, but it's still showing on the screen. So if somebody, I can just decline it 1 minute. I've done that. So we'll go back to our presentation. Okay. So when we were talking about the legal validity and recognition of electronic documents and digital signatures, as I said, paper-based documents and also the electronic records, they can be, legally, they are legally recognized under the Indian law. And the signatures, electronic signatures are also accepted like the hard copy, the actual signatures you make, handwritten signatures. That is also something which is allowed, and that's possible. So now what we have to see in this regard is that the IT Act has a huge stretch of sections. The certifying authorities have a role to play. They issue digital signatures, and the civil and criminal liabilities are also there, outlined in the IT Act. The Office of Adjudicating Authority has also been made, which looks into all the contraventions, the civil wrongs, as we call them, which are different from the offenses under the IT Act. And the power to investigate these offenses is with the inspector and above rank. That is the current law. Earlier it used to be the DSP and above rank. So now that brings me to the overview of the IT Act. If you look at the sections and the definition, very important is one definition in the IT Act, which is the definition of a computer. It is very wide. It says means electronic, magnetic, optical, or other high-speed data processing device or a system which performs logical, arithmetic, and memory functions by manipulation of electronic, magnetic, optical impulse, and includes all input-output processing, storage, computer software. I'll pause here. It also includes communication facilities. So imagine all the emails you're using, all the voice recordings that are happening, voice conferencing facilities, social media, in any kind of voice over IP, messengers. All these are also communication facilities now. So they are all included, in the definition of the IT Act again. So now what happens in such a scenario is that if you look at the computer network definition, so apart from computer, the definition of computer being so vast to include all the communication facilities, the computer network also includes any kind of interconnection of computers, including wireless or other communication media. So if you look at the definitions of the IT Act, they are very broad, and now they have been amended to include the latest modus operandi and latest technologies, which are deployed in the cyberspace. So the act and the definitions are very important. Whenever we look at any cybercrime, we have to look at the ingredients being satisfied. We look at these definitions along with the sections, which are key sections. Interestingly, the computer resource word also is important here. That is defined by section 2(1)(k), and it includes computer system, computer network, even data. So data is very important. Data is a new oil, we call it. So that is also included. The software and computer database, all these get included in the IT Act definition of computer resource. Now, when we talk about the extent and definitions, there are far many definitions we possibly can't cover all, but I have just highlighted the key ones. Another one which I'd like to highlight is the intermediary. The definition of intermediary earlier has had a very restricted meaning. Now it not only includes all these telephone broadband companies who are giving internet services, but could possibly include all these service providers like even social media platforms, online shopping malls, which are sort of an intermediary between the user and of a service and a service provider. So that therefore the definitions are very important from that. Second chapter of the IT Act talks about digital signatures and electronic signatures. Now in this, when we discuss digital signatures, electronic signatures, under our current framework, the digital signatures are meant and then they're given a presumption in law that whatever is signed digitally is secure. Not only is it secure, it is protected, it is not tampered, and the originator of a message, for example, a digitally signed email, there would be nobody else intercepting. The data is not tampered from going from person A to person B. And the technology we are using is the PKI method, which is the public key encryption method. And using that, there is a hash algorithm which is computed, which secures the data. That is what is reflected even in the IT Act. And any message which is digitally supposed to be in secure electronic form as IT Act. Then we also look at chapter 3, where there will be electronic evidence governance, legal recognition of electronic records. So where law is providing that an information has to be in writing or it has to be in a printed form, even if this requirement be deemed to be satisfied if this is made available in electronic form and accessible to be usable for a subsequent reference. So even if it's an e-document, electronic document, you can actually prove it, and it is legally valid and recognized by section 4 of the IT Act. That's how the law provides that. Similarly, legal recognition to electronic signatures is given under section 5 of the IT Act. Now, that takes us to the attribution, the acknowledgement and dispatch of electronic records. To put it in a nutshell, if there is a digital signature, for example, if there is a designated email ID, if a message has to go from a person A to a person B, and somebody has given his official email ID, this is where you need to send me this contract. And the person sends this contract on that very ID. So the time of receipt of this document will be deemed to be the time when it hits the server of the recipient, and not when he actually reads the message. That's what the IT Act says in chapter 4, that the timestamp of that particular, it will be deemed that he has read the message, because the form this designated email ID, it is a dispatch has happened and the receipt also has happened. The time of receipt will be that. So that's a very interesting concept. But if a mail is sent on another email ID which is not officially communicated to me, will be only considered receipt when he actually reads it. So the time of receipt in that case is very different. That happens in chapter 4. Chapter 5 discusses about the mainly about secure electronic records, and that what are the attributes which grant it a secure status. So the security procedure which is prescribed here is one of them will be the digital signatures. Now, of course, the government has also included Aadhaar based KYC also as one of the means of digital, like digital signatures of secure way of signing. So that is also considered, and as a schedule to this IT Act, that it is a secure way of signing. So that is another aspect of the Act in terms of secure electronics and electronic signatures. Then Chapter 6 talks about the certifying authority's role. Consider a pyramid. At the top of the pyramid is the controller who is the main authority looking after digital signatures. And then comes the certifying authorities who further gives issues the certificates to the subscribers.
Just a minute, ma'am. Ma'am, many of the participants have. Hello.
Yes, Rajivji.
Ma'am, many of the participants are saying that audio is not very clear.
Okay. Please give me a second. I will just check.
Yes, ma'am. Yes, ma'am.
Is it better now?
Yes, ma'am. Yes, ma'am. Now it is better.
Much better. Good.
Please, ma'am.
Much better. Okay. So, may I
Yes,
continue then?
Yes, ma'am. Continue, please.
Okay. So now the regulation of certifying authorities is something that we deal with under Chapter 6. And here I was telling you that a controller is at the top of the pyramid, and then comes the certifying authorities who further actually issue the licenses and the digital signatures to the subscribers who are either entities or their. So that's how the certifying authorities function. And any message which is electronically signed and has somebody who's been issued a digital signature, the certificates are presumed to be correct. That's Chapter 7 of RIT Act also talks about what is the electronic signature certificate and what all information is there, and how this is issued. The certifying authorities can issue the digital this electronic signature certificates. So here, if we go back to chapter 8 now, after that, duties of subscribers. The duties of subscribers, they are supposed to give a pair, generating key pair, which is in the digital signature there's a private key and a public key. So private and a public key are basically used together to form that secure electronic document to sign the document. Now the digital signature certificate, public key, they correspond to this private key. Algorithmically, it is connected like a lock and a key, actual lock and a key that you see. Similarly, you can conceptualize that that is a private key and a public key, which is used to sign a document. So that's what, there is a key pair which is generated, and the duties of a subscriber of electronic signature, they are basically given under the Chapter 8. Then also very important is the control of the private key. It is secure, it is confidential. That is what is sort of a duty of every subscriber. If I have a digital signatures to file, say, income tax return or something else, then what happens? I have to keep it secure. So nobody should leave this on their systems, so anybody can actually misuse them. That's what the section 42 says about the control of the private key. He has to reasonably exercise all particular care that is necessary in that. Now comes the Chapter 9. Very important is this Chapter 9 because section 43 of the IT Act takes care of all this, where if there is an unauthorized access by any person on any computer that doesn't belong to him, and he steals data, or he takes away data or damages data, where this is a civil wrong. So there is no, even if there is no malintention, there is no intention to commit a crime, but he does cause this, maybe out of negligence, for example, then he is damaging the system. So he is answerable and he is liable to pay damages to the person whose system he has damaged. This section 43 is usually read with 66 of the IT Act, which is the section relating to hacking. And there, what happens is the mens rea is also there. That is the mental intention to commit a crime along with the actus reus. In those situations, the penalties are there. You can go for criminal penalties are also possible in such a scenario where the mens rea is established. So chapter 9, talks about section 43 and 46. The adjudicating authority is the right forum, the right officer appointed to decide civil wrongs, which are contraventions under chapter 9, as opposed to offences which go under criminal, I would say jurisdiction of criminal courts, which is a different procedure altogether given under CRPC. Chapter 10 talks about Cyber Appellate Tribunal. Cyber Appellate Tribunal is empowered to hear appeals from the adjudicating authorities' orders. But now this is merged in, in TDSATCO, which is the Telecom Dispute Resolution Authority here in Delhi. That decides the matters across India coming from the orders of in appeal from the adjudicating authority. That's how currently this system works right now. And then chapter 12 talks about intermediaries, and the intermediaries are not liable in some cases. There, section 79 of the IT Act says, for example, if there is a social media platform and there is a defamatory post about somebody on it, very common problem today, and somebody, the aggrieved person complains and files a suit, he wants this to be removed. So, before filing the suit, if he actually writes to this social media platform, they are supposed to remove this within 36 hours as per the IT Act. If they don't remove it, then obviously, you can sue them because they have got actual notice. And if they don't remove it despite getting actual notice, then they are liable. Otherwise, they have immunity. So that is the whole crux of section 79 of the IT Act. Then there is another section, 79A, Examiner of Electronic Evidence, in the next chapter. And there it's all about, chapter 12, this is. The Examiner of Electronic Evidence is the body which is appointed by the central government and decides any kind of issues which pertain to authenticity of electronic evidence. For example, there is a private lab which has given a report. There is a government lab which has given a report. Who decides which report is correct? That could be, the role of this, is the role of the Examiner of Electronic Evidence. And then comes the miscellaneous sections in the IT Act, which are, miscellaneous sections also include the power to investigate and offences being with the inspector, the civil court's jurisdiction not being barred in cases of copyright and such another, provisions. Now, I just want to discuss very briefly the jurisdiction in online cases. What happens in cases of jurisdiction is that, if you have to decide the jurisdiction in a case online, which is an maybe instance which has happened relating to, say, trademark or copyright or any other instance, how do you determine that? There is a Zippo sliding scale approach which we have adopted from the US, and in India currently we are adopting the effects and the targeting test principle, wherein what happens is that, for example, in a defamation case, if a person X is defamed in a jurisdiction, say India, and the defaming site is based out of maybe another country, he can sue, he can sue this service provider if it has been targeting users in India. We have jurisdiction by virtue of this targeting customer approach, as per our Indian cases also, the banyan tree holdings case and other cases which come about. And this issue is pretty much decided in such a way that in many cases it is being adopted that if this foreign website is catering to Indian audience and Indian users are being targeted, then if it does something which is illegal, then they are answerable to courts in India. And we have adopted this approach in this Nirmaljit Singh Nirula versus IndieJobs case, where we argued this matter and said that a foreign website posting content about an Indian person was defaming the Indian person. Therefore, they have to remove these pages from their site, which finally, was achieved. So there was an interim order whereby the registrar of that website, pages.com, was asked to remove those pages, and the matter was analyzed. So that's how we see, cases in online defamation or online jurisdiction being established through these principles. Then there have been several other cases like the Super Cassettes Industries case, and there the same target approach has been used. It was a portal where some pirated music and some pirated movies were being uploaded by users, and the court observed there that if the defendant is continuing to publish this infringing material even after receiving this actual notice, then it amounts to authorization, sanction, or approval. And from the point of view of jurisdiction, I brought this case that the plaintiff, he can sue this particular company, MySpace here, because it carries on work under section 62 of the Copyright Act, apart from the grounds under section 20 of the CPC. So in this situation, a plaintiff's right is there because its copyright is infringed. He can also sue from there. So in India also, the jurisdiction lies against this MySpace Inc. because my copyright has been infringed. Similarly, on the other side of the spectrum, if you see a virtual, plaintiff, why I'm saying virtual, because he doesn't have an office in India. It never has an office in India physically, but has customers in India. So WWF sued one of the Bombay-based companies for infringement of their trademark because this Bombay-based company was selling some, products with the trademark of WWF. Although WWF never carried on business here, but it was physically it was not there, but virtually they had business, in India. So they were held to have jurisdiction. The courts in India would have jurisdiction, and they took assume this jurisdiction that way. So very interestingly, I mean, these principles apply. And in this Vodafone India case, it was also held that the section 81 of the IT Act, which otherwise bars jurisdiction of civil courts, are not allowed to take up those matters which clearly fall under the purview of the IT Act. So, but copyright is excluded. So copyright, you can't exclude copyright cases under section 81 of the IT Act, and patent cases also. The civil court have the jurisdiction in those cases to deal with those matters. So that is also something which is very clearly spelled out under the law. So the act will not have an overriding effect on such cases. That's what particular section says. Then blocking of web pages. I had given one example of this Nirmaljit Singh Nirula case. There were other cases like the Vyakti Vikas Kendra case where similarly, blocking of pages has been achieved. The long and short of it is that if there is a particular blog or a particular article and written on a site which is a social media site or a blogger site, you can actually complain and get it removed. If it doesn't remove, they can be sued in the court. There could be a suit immediately filed for injunction, and orders can be taken for blocking. Then let's go back, from civil, aspects to criminal aspects and see for a minute, how do we determine jurisdiction in criminal matters in our cybercrime cases. Now, if we see that sections, of example, in defamation cases, where the act is done and the consequence of it is felt, in both the scenarios, there is a possibility that there will be a jurisdiction in those cases. There is a determination of jurisdiction possible in those cases. So for example, we dealt with one of the cases, very interesting cases, where a director of a very important, like a big company, was defamed in his headquarters somewhere out of India. The headquarter company received a lot of mails against the Indian director. So the question was, where would the jurisdiction lie? Would it lie in that foreign country or would it lie in India? So now, where the act was committed, where the offense was committed from, that is one jurisdiction. Now, in cybercrime cases, many times it's difficult to find the initial point, where this has been committed from. And especially in defamation cases, it is possible that you have jurisdiction in also the place where the victim resides. So if a computer is hacked at a place X, you can sue there, you can file a complaint there. And also, if in the case, for example, in defamation, you can sue where the consequence of it is also felt as per section 178 IT Act. So there are lots of different situations in a different I would say cases, which would be instrumental in deciding where exactly we need to file a particular case in the criminal jurisdiction aspect, if you look at that. Then let's come to section 43 for a minute again and see the ambit. It's very wide. So it covers all unauthorized access, downloading, copying, introduction of a virus, damaging a system, disruption of a computer, denial of access of a service, time thefts, damage to data, stealing source codes. In such a case, the person is liable to pay damages. So the victim can actually, the aggrieved party can actually file a case before the adjudicating authority, who looks into the complaint and then gives compensation. And there are some principles for granting of compensation. For example, how recurrent is the act? How much damage has been caused? Is it being repeated over time? And the frequency. A lot of these aspects are looked into when the grant of compensation takes place. Then section 43A is also a very important section for all body corporates to collect information about people. You would have seen that a lot of times, food apps, for example, these days very easily ask for a lot of data which is not required. The other day I was downloading a food app and I realized that it's asking me for access to my contacts, my photographs and videos. Now anybody who is not so well aware of the laws, he would just, or not being careful, he would just click on I agree and just download the app without realizing that it's so much of information which is not needed and given away. So this section is very important from the point of view that whatever is taken by the service provider, if it's something which is reasonable security practices have not been implemented by that body, number one, it would be liable for that. And number two, in many cases, the if you see the legality of collection of such data, the PDP bill which is underway is very important in that, because the personal data protection bill has very strict guidelines on, and in fact mandates on what information can be collected, how long it has to be kept, and it is also something which by which it decides the retention period for how long they can keep. They have to delete it after some time when the service is over. And there are a number of, I would say, checks and balances which are needed in maintaining or collecting, keeping or processing the data. So for what purpose are you collecting data? That is also supposed to be very explicitly and clearly given in information to the user before collection of this information. So all those things, the privacy regime is going to be strengthened by bringing in of the PDP bill. And this 43A may maybe have to be amended or replaced by a new section at that point. So here, if we see this, I was talking about the PDP bill. If the penalties are so, I would say stringent, as Euro 20 million in GDPR, up to 4% global turnover. In our Indian GDP will also similar, stringent punishments are there, and therefore there is a greater need for compliance now, because there will be, after the act gets passed, and especially after this Justice case, Puttaswamy case, the 9-judge bench of the Supreme Court, under the Supreme Court, has held the right to privacy as a fundamental right. So most companies are changing their policies, IT policies, their work from home policies these days, what data is to be collected, how it is to be processed. Everything is going to be going through a sea change, especially post-lockdown. When we're talking about sustainable businesses, a lot of it is changing in terms of the transmission of information, the retention of information, and obviously the collection comes first. Then liability of ISPs. ISPs are definitely now termed as intermediaries under the IT Act, but the onus of proving that they did not have actual notice is on them. So if they get the actual notice and they don't remove this particular defamatory or other content which is illegal, to obscene or any content, then the liability lies on them. And Section 85 of the IT Act is deemed liability of directors. So it deems that the managing person who is managing an execution of the entire office, the way the effective functioning, if they are in charge of that, then they have to prove that they had neither knowledge nor intention to commit a crime, to escape liabilities. If they have got actual notice, they have to remove as per Section 79 of the Act within 36 hours. It is a different case when it is just a phone company providing a broadband service where they don't choose the receiver or sender of a message. Those people, I would say, those section of ISPs or the intermediaries have immunity. They would not fall foul of this section, really. But the others can, and therefore they have to immediately take action when they get actual notice of any content like that. Now, this brings me to the aspect of cybercrime. I just in about 5-10 minutes, I want to give you a very interesting overview of what happens in today's world of cybercrime and dark web. The dark web is just the we call it as a, what we see in today's world is this as the internet is just tip of the iceberg. There's so much happening in the dark web. What is dark web? There are a lot of people using Tor as a tool, or anonymous proxy servers which hide their real identity. I'm giving you an example of an onion. So when you peel the onion one layer after the other, there are layers and layers. In similar terms, it's called as onion routing in our cyber terminology. There are layers and layers of IP addresses, which are computer addresses. Like you have a home address, every system has an IP address. They camouflage, they hide the real IP. There are tools, softwares available, websites available, which help one do that. So the criminals take this identity and they hide their real identity, commit crimes on the dark web. And most of these crimes are not new. Some of them, like blackmail or criminal intimidation, bullying, forgery, embezzlement, what used to happen offline now is happening online. So computer crime, if we call it, or the cyber crime we call it, it's basically the same thing, because it is a crime which is where the computer is either a target of a crime or the means adopted to commit this crime. So most of these crimes are not new, and they can be categorized. They can be categorized into 3 parts. We kind of categorize them into crime against government, crime against property, crime against persons. So things like cyber terrorism. Supposing a terrorist tries to attack the power grid of a nation. We have seen examples have happened in Estonia, hacking attempts. Then hacking and sabotage, credit card frauds, these are very rampant today. Fake calls come asking for OTP, asking to share credit card information or some fake lottery scams, and credit card details. And this is not something new today. It's happening everywhere. And even some, people who are educated, people who are professionals, they also fall in the trap of these people. During COVID itself, I've had several queries where people have been siphoned, their monies have been siphoned away with apps or donation sites, fake donation sites running the PM's donation handle, which is a fake handle. Like this is the extent of crime, today, that there have been fake websites of astrologers, of psychotherapists, and of medical specialists. And during COVID times, fake education portals. They're taking information, extorting monies afterwards by blackmailing. They take away access through malware or keyloggers. We call them as keyloggers. There is a malware which infects the system if you click on a suspicious link, and that can infect the system, and the system will convert itself something like a CCTV. Whatever you're typing on your system is visible to the cyber criminal because he has infected your system. So this is the level of technology and exposure and breach of privacy that can happen, through the cyberspace. One has to be very, very careful. And I've run a series of webinars around this time only to talk about online safety and how, what is the modus operandi of criminals, how we can protect ourselves online. And my, basic tips on those were not to click on these fake fictitious links, and especially on social media, how these are going viral and people are, without realizing, downloading a lot of data, even ebooks they are downloading, which may not be coming from the original source. So it's always good to go to the original web, that authority, and take information or information resources rather than those which are floating on the internet. What are the statistics of COVID, for example, right now? People are downloading any and every information which is coming along to them, WhatsApp or Facebook or any other medium, I would say. That's what we're kind of sounding people, that these are all social engineering attacks. So we need to all be aware of these problems. Then comes the online gambling. Online skill-based gaming is different from chance-based gaming, and a lot of children are falling prey to online gaming these days because of excessive use of it. That's what we have to be very careful of, that we don't encourage online chance-based gaming. I think there is some audio playing at the back. Can somebody just mute the other mics, please? Yes, thank you so much. So IP crimes, we've just seen how copyright infringements and trademark infringements occur when it comes to trademark infringements and copyright, whether it's movies or any kind of music remixes, sound albums, they are being infringed online. Trademarks are being infringed online. Then these spoofing attempts, as I said, there are a lot of man-in-the-middle attacks, we call them. Man-in-the-middle attack really means, supposingly there's a buyer who buys, say, garments from an X location abroad, and there is a seller. So the person in the middle is basically somebody who is working for either the buyer or the seller. Most often, it is the seller, because the payment invoice which is generated is tampered with, is forged by creating a fake email ID which resembles the actual accounts of his email ID. So he creates a confusion between the buyer and the seller by creating false email IDs and changing the invoice. So as a result, when the buyer sees a fake invoice, he sends money to a location which is not the authentic bank account of the seller. That's what is also very common these days. Forgery, which is clear in this example, malware affected files, defamation we have already covered, and cyber stalking and identity theft. So a lot of times we see fake profiles being created online, and women being trolled, or even anybody, in fact, any gender can be cyber stalked. And there are provisions to deal with that, which we will just come to. But it's shocking to see. You see, the crime against women, especially, has increased 83% in the last 10 years. It's a very shocking, statistics. And overall, if you see, crime rate has been increasing every year. It's doubling, or even sometimes it's been 77% as per NCRB in the last data that they have disclosed. 2018, 17, and 16 data. If they compare that, and 20% rise in children related crimes also in cyberspace. So the statistics clearly are very clear. And this slide basically shows you the kind of crimes and how we can categorize them in various heads, including sexual harassment, cheating by personation, child pornography. Child pornography itself has been a huge area of concern, even with the Honorable Supreme Court. We've had cases like the Kamleshwar Swami case and Prajwala case at the moment, and then there have been various discussions on blocking child porn, and we are still I think some time to go before we finally find a foolproof technology to deal with it. Currently, DNA technology is being used to curb child porn. It helps trace duplication of content images which are obscene in nature, and with the help of that, they are trying to curb this problem. Then stalking and sexting. Sexting is yet another term. It's messaging of adult content or any kind of obscene content to each other, and very rampantly done in schools and children these days. And grooming. So we've had instances where children have been groomed. This word really means when a stranger tries to engage in a conversation with a child, and later on, once the interest hobbies are discussed, he tries to do uh, discussions further with the child, which are for illegal purposes of sexual gratification or otherwise to create child porn and things like that. That's again a huge concern, and cyberbullying is another concern. And it's a pretty dismal situation because children are committing suicides. They are under depression, and lockdown period. It's very difficult for mental health and well-being of people. And we are all going through a time which is transition. The gravity of the situation is such that the online schooling is happening online. They have really access to a lot of internet all the time. So the need for netiquette, we always tell when we talk about children and online safety, we talk about the need for netiquette. When you give them computers and you give them the gadgets, you also need to tell them what are the do's and don'ts of using this space and how to safeguard themselves. So given this setting, we see most crimes under the IT Act, which are offences, fall under section right from section 65, 66 to 70. And here they talk about hacking. Hacking has a 3-year term punishment, 3 years and fine or more. And identity theft similarly is 3 years and fine or more. Cyber terrorism is a very strict punishment, up to life imprisonment is also given. And 67A is again up to 5 years. And then you see section 66, 7B, again 5 years. But other than that, most of these sections are violation of privacy, creation of MMSs, for example, where she feels there is an expectation of privacy, but it's been breached, 3 years term punishment. So most of these offenses, barring a few, like I mentioned, cyber terrorism or child pornography, they are punishable with imprisonment up to 3 years, and they are cognizable, but then they are bailable, and only 3-year and above terms are cognizable and non-bailable. This is basically the snapshot of the same, but even abetment to commit an offense and attempt to commit an offense has been made a crime under the cyber law. And the latest Shreya Singhal case, the 66A section was struck down as unconstitutional by the court, the Honorable Supreme Court, because the language of the section was very ambiguous and could be misused or misinterpreted to a large extent. So things like harmful to minors or offensive were not very clearly defined. Parameters were not very clearly defined. So that was struck down. Often I get to hear this query that now that 66A is not there, we can write anything on the web. But I always, emphasize that that when it comes to IPC, we still have those sections. And if anything anti-religious is written or anything which outrages, say, any kind of anti-religious sentiments of people, or creation of riots or instigation of other cognizable offenses, we have IPC with all these as still offenses under the law. So even though Section 66A is not there, doesn't mean that we can write anything and do anything. It's not a lawless world. At least in India, we have the other apart from IP Act. There. So here, this is a snapshot of what are the key provisions we generally use. These kind of cases come along. We have barbarism provision 354C. The IPC, again up to 3 years of term of punishment. Sexual harassment is again up to 3 years of punishment. And then we have the outraging modesty of a woman. There's sections on receiving stolen computer source. And there are a lot of, say, theft is there. There are a lot of other sections in the IPC which we continuously use. And remedies, if you say for cybercrime, then yes, we have civil, I would say for compensation or for contravention, we have the civil officer, which is the adjudicating officer. When it comes to cybercrime, once the reporting is done, we have the helpline. We have the cybercrime.gov.in website for reporting of this cybercrime. And for all these, cases which go, criminal investigation takes long, and we have the criminal courts would look into that. Sometimes both civil and criminal, remedies go together. It can be both the things. For example, in a hacking scenario, also it could be both that can be applied, but even blocking of websites and definition. So that's what we've seen, and I'm sure we are all dealing with these issues every day. There are more and more cases of cyber crimes happening across various states now, and I'm sure state of J&K also will soon have a lot of these cases will come once the reporting happens. A lot of them are not being reported, and that is why they're not reaching the courts. But very soon these will rise because these things are happening and the awareness is spreading in a lot of different states. So when we talk about the challenge, you say the challenge of convictions, how good are the conviction rates in India? In especially FOXO cases, I was going through a figure with IT Act, there were only 2 to 3% conviction rates. So the conviction rates are very low, and as per NCRB data, there were only, I think, 200 cases which were finally decided in the last statistics which I've seen, where IPC and IT Act were kind of attracted together in certain cases. So we still have a long way to go, but nevertheless, these provisions will have a lot of value and weight, and a number of cases where the police now beginning to investigate because they already have received trainings and they are aware of how to investigate. They're beginning to chart sheets properly, and everything is happening timely. The social media portals beginning to cooperate also now, giving electronic evidence, which we are now going to discuss very soon. So during the COVID, I had said that there was a rise in cybercrime, and the figures have been very, very, and very, very steep. 86% as per MHA, and 8,300 complaints from individuals across India and NRIs who donated thousands of dollars into fake accounts. So at this point, the criminals are taking advantage of this times of crisis and are on the full swing of committing crimes. And this slide basically gives you a snapshot of the kind of crimes which are percolating, especially phishing and fake news and malware attacks, and also ransomware. Ransomware is basically where malware would infect a system by somebody clicking a link or opening an electronic file, and it would hijack the system. Hijack the system in such a way that it will lock the entire files of the system, and unlocking will only happen once the person who has locked it unlocks it, which for which he demands money. It's like an extortion racket, and this is again very common. And we've seen a lot of instances like these and looked at these cases. And sometimes we get a key, solved key to resolve this case online through public platforms or otherwise. But many cases, the key which they have used to encrypt that information is not available freely. So it creates a problem there. Now this is example of how FIR has been registered in one of the recent cases where PM Cares Relief Fund, a fake handle was created by a cyber criminal. And these cases are rising every day. And the latest cases which we have seen in the cybercrime world is the cryptojacking. Bitcoins, cryptocurrency being used, basically programs are being created which would mine data in a computer. The hackers, what they're doing, they are basically using cryptojacking. It involves hijacking of people's computers to mine or run programs which produce cryptocurrency. So you don't even know. Earlier, we used to have this concept of steganography, where a music file, for example, you would think it's a music file and you're listening to that or it's on your system, but behind that, there is actually some other illegal content inside it. So similarly, a lot of times hackers are using cryptojacking technique to hijack people's computers. A third example is the bot network, which is a robotic attack. And the system is compromised and the person doesn't know the system is compromised. It is working for a team of illegal criminals. So that's why we look at robust technology, anti-spyware, anti-malware to check if our systems are secure, because there are a number of ways in which hackers are attacking systems today. And a number of cases have been decided by the Indian courts, like the Asikuddin case, where it was held that when a source code of a mobile phone, for example, is tampered in such a way that that device, which only worked with one service provider, starts working with another service provider, the internet broadband starts working of a different company on that mobile service, then that has happened through tampering of the code inside is illegal. Then similarly, there have been data theft cases. Latest one, which was the Rishi Dixit versus Preventine Life Care judgment, where they the issue is of data theft and employer-employee relationship. So how the sections of 43 section and the other sections are being interpreted in the IT Act and hacking. So that's very interesting to see the electronic evidence part which comes along. How do we prove that this really happened? And a number of electronic evidence parameters become very key and important at this point, which we will be discussing. Then there was this Bazi.com case, which was one of the earliest cases, in the cyber domain, where auction site was used to take away a lot of information. This Bazi.com case, obscene content was highlighted of a particular MMS, and I correct myself on that. Bazi.com, the director of the company at that point was arrested, but later on in the Anita Handa case, in appeal, this at that point it was held that the company was not even arraigned as an accused, so the vicarious liability of the director cannot, because in section 85, the vicarious liability of directors, invoked. If a particular company commits a crime, there is a crime which happens, and the director ought to know that, ought to have stopped that. In this case, it was held that since the company was not arraigned as an accused, so therefore the liability was drafted. Similarly, there have been other cases, like of conviction in Tamil Nadu versus Suhas Kati case also. This was a sentence of 2 years for, again, obscene content. And likewise, there are a plethora of other cases. We didn't go into too much detail at this point for the test of obscenity in a nutshell is if you are a responsible reader and you find a content obscene, that is a test which we are following currently to determine obscenity in the cybercrime cases. Shreya Singh's case we have already discussed. But yes, cyber safety practices, we are using WPA 5.5 systems now, keeping our software OS updated, thinking before we click, reading the terms of use, using digital signatures, using two-factor authentication, especially for net banking, and paying only on HTTPS sites and registers for bank alerts. These are some of the very important security practices we are trying to create among people at large. This brings me to electronic evidence, and when we see Section 3 of the Evidence Act, it takes care of this admissibility aspect, that paper-based records, just like they are considered as documents, they can be produced before the court. Even the electronic records are admissible in the court. Section 4 offers, the IT Act offers legal recognition to electronic records also. And electronic evidence includes now computer evidence, digital, audio, video, cell phones, CCTV footages, digital fax machines, and every kind of possible line electronic media. Now, obviously, there is primary evidence we look at and secondary evidence. But when it comes to primary evidence, if it is an actual phone with which the crime has occurred, that is a primary evidence. But if it is a recorded version of it, if it is a electronic version of an email, maybe an email, how do we prove? The whole server cannot be lifted, the whole system may not be able to take it to the courts. So what we can do is we file secondary evidence. Now, a lot of times the secondary evidence will have to be proven. Either it will be through Section 65 A and B certificate or by other means. So here, when we look at documentary evidence, Section 65 B, mainly Section 65, it relates to those cases where the secondary evidence can be given of the existence, condition, or the content of the document. What is the content? And in Section 65B, it talks about admissibility of electronic records. So the computer should have been working fine. There shouldn't have been a tampering of the record. In the ordinary course of business, this data would have been entered into the system, and it is derived from this. The information is derived from such a record that was fed into the computer in the ordinary course. In the US, we normally call it as a business exception, the business records exception, and we've seen that same principles happen here all over here in India, and the certificate which is required should say all of that, and the chief technology officer of that company who has that record machine needs to testify that and put it in an affidavit. That's what is required by Section 65B of the Evidence Act. Now, the question arises that initially we had the Mohammad Afzal case, and where they said that even if you don't have the certificate as a proof, you can lead it by other means, maybe testimony, person or a witness, and that's possible. But later on, in the when you see the Mughal versus Bashir case, the certificate was said to be mandatory to prove and a particular electronic evidence. And the Shafi Muhammad case later on, we have seen that there is a clarification given that a person who doesn't have that record, maybe it's put up by a service provider and he has the possession of the entire that record. So the person who is affected may not have the exact possession or custody of that electronic record and should not be the person who's testifying the same on an affidavit. So in those cases, he needn't give. He can actually prove it by other secondary evidence possibilities, and that's a testimony of a witness or anybody that he thinks can prove this, help him prove this case. Now, this has been the trend, So the kind of provisions which get moved in, apart from Section 65A and B, there are a lot of other provisions in the electronic evidence and records which are applicable. If we look at this slide, for instance, proof as to digital signature, whatever is a digital signature signed document, it is presumed to be correct also. There's a presumption here as to electronic agreements in 85A, presumption as to electronic records and digital signatures in 85B. And 85C talks about presumption as to digital signature certificates. So there are a lot of different, provisions in the Evidence Act also, which are very important when we come about proving or looking at admissibility of electronic evidence. On whom is the onus after all, and do we have a presumption in our favor? If we have to prove a particular document is correct. This slide also shows you the kind of presumptions that are there. And in many occasions, there is a, okay. So the presumption in favor of a digital signature or electronic record, which is 5 years old. So if it is a 5-year-old document, there's an automatic presumption this is correct unless it's rebutted. Similarly, opinions of examiner of electronic evidence, they're also important. And in Section 79A of the IT Act, this is also very important when we discuss, the role of the examiner of electronic evidence and how he helps in proving this document. Then, when we talk about the other important aspects, when we say collection of evidence can happen through many means. In IT Act itself, we have a lot of ways in which we collect data. The Section 69A is talking about blocking of access. That is a different thing. Then we have traffic data, which we can collect. That is also possible under the IT Act. And the central government has the authority to do that. This slide shows you this, how the government has the power to intercept under Section 69. And 69B, it collects a lot of data, which is stored in a computer. So, if you see the role of the examiner, he's definitely given a final say on what is correct. Apart from the private labs, the government labs may give something that decides whether this office. These are the authorities which have been raised to give have the status of the EEE under the IT Act right now. This is as per the details on the website of MIT. Then we also need to know the collection of data of electronic evidence happens through we look at computer forensics. It plays a huge role in collection of and appreciation of data, because the reports which are produced by the forensic labs look into all these aspects, whether the data has been identified, preserved, how the hash value matches or not, the main disk involved and the destination drive, the imaged disk, because the entire forensic takes place on the imaged disk. So if the disk is studied to find incriminating material there, what is the material? We use a lot of keywords to understand whether the criminal had actually deleted data or not. And there is a different level of forensics: disk-based forensics, network-based forensics, mobile forensics, and email forensics. So we have various layers of checks which we can get. Various softwares we use like Access Data to understand what is the electronic evidence. And these are the ones which are produced, in court. We look at existing files, deleted files, internet history, and other means. And using these kind of tools, we recover data. Sometimes criminals have deleted the data. That is also recovered. And FBI handbooks, for example, CBI also has their handbook. They have various ways in which they are taken and kept: keyword searching, limited source analysis, slack space analysis, and then email forensics. So that also is very important because we look at how this email has come about and where it has come about. So just want to summarize now that in the amendments in the Evidence Act, we have seen right from the case of state of NCT Navjot Singh and then Muhammad Asal case. In Anwar versus Bashir, the entire changed with need for the certificate. We have to have a certificate to prove admissibility of the document, electronic record. In Shafi Muhammad, the things changed that when a person is not in possession of a device which has to be produced, it cannot be required to produce the certificate under section 65B that was held. And lately, there is this Arjun Pandit Rao Patkar case where the reference has been made to a 3-judge bench, and this has been considered. There is a need for certainty on this issue of legal admissibility of electronic records. And I think Shafi Muhammad case will be looked into whether this is actually doing the right law. In my opinion, they should be referred to a 5-judge bench because if it has to be examined, the principles in Anwar versus Bashir and the principles in the other case, this Shafi Muhammad, probably needs a 5-judge bench to decide this issue. So when we look at UK and US position, again, UK law has changed. And just in one slide, I want to tell you that now there is a presumption that this evidence which is given is correct, electronic evidence, unless the other party rebuts as per the UK law. In US law, we continue to use the business laws exception. And they are again admissible. You can prove it by either a certificate or otherwise testimony of custodian evidence. We straight away go now to one slide only, which I want to show. The voice recordings, they are admissible in a court of law. We know that. There have been many other cases, right from Dharamveer versus CBI, and there have been cases, Praful Desai, in which video conference facility was held to be valid. On various aspects of electronic evidence, there are various cases. We possibly can't cover all here, but majorly the Muhammad versus Muhammad Afzal case, the Anwar versus Bashir, Shafi Muhammad, now this case. I think they are the main pillars, milestones in the journey of electronic evidence. And we'll continue to see more this space because the one aspect which is the key highlight is that when it comes to admissibility, these are the principles which are being adopted, but it is different from authenticity of the content because there are different principles applied. Once the document is taken on record, the proving of that, the accuracy of the content is a different aspect altogether. So there, the otherwise laid down principles of Ramsing in other cases will apply, will continue to apply. Now, I think we are sort of short on time, but I want to take questions. I just want to quickly let you know that there are 1 or 2 very interesting sites we use to gather electronic evidence, which anybody can, like the whois.net, where we can find out who is the owner of a particular website and the registrar, when was it registered. And we often use Wayback Machine to see if a criminal has taken a particular web page off its usual web page. And we can go back on time and on a calendar to see what was the information on that day and when was it removed. So there are very interesting tools available even to detect fake news online, like these websites which help you understand that this news is fake or not. You can just run a check in the search window. And what is my IP? We gather electronic evidence through this also to see what is the IP address, from where an email was sent, for example. Take that IP address from where it was sent. We put it in this. We are able to detect that. There are a number of resources I would, suggest. That's one of my books which I had authored, Computers, Internet, and New Technology Laws. And there are a few other ebooks. One is on child victims of cybercrime, which we wrote for the NCPCR, protection of children on the internet, and a few more e-resources on which are available. There's a free app also, which you can probably use, IT Act and Cyber Law India, by Lex Cyber. And the idea of creating these resources is obviously a dissemination of knowledge and sharing. And this forum, I especially thank the Judicial Academy of JNK and Rajiv ji and Honorable Justice Mittal for having taken this initiative. I know time has been short to cover all that we can possibly cover in this whole space, but I've tried to do whatever best I could at this point, and I'll be very happy to answer any questions from the audience. Thank you so much for a patient hearing.
Thank you very much, Dr. Karnika. It has been a wonderful session. I'm well aware that this discussion cannot be completed in a time span of 1.5 hours. It's a matter of days together that we can learn the nuances of cyber law, cyber security, and other related matters. But still, in the given time, you have done justice with the topic. Now, we will take few questions which are there in the chat box. There are few questions which generally say how to categorize the electronic evidence. Would it come within the ambit of primary, secondary evidence, referring it to documentary evidence, or it's altogether a different set of rules which govern the electronic evidence? So what is your take on it?
When it comes to any device from where the offense has been made, or a particular act has been made, or a document which is there on the device, there it will be if you're giving a particular device itself, it is a primary evidence, because there that is the device itself. That's the original. And if it is a secondary evidence, prove normally, because there's for example, there's a server of a company. You can't possibly take the server out or the entire system or machine out. In those cases, we will call it as a secondary evidence if we are producing a printout of those relevant documents and certifying them under Section 65 and saying that this is authentic, coming from this machine. The machine is not tampered, is completely working condition, and even if there was a malfunction, it has not affected this piece of evidence. So those are the provisions which are there in Section 65B of the Act, and if we are compliant with all those criteria and there's a certificate, then that can be led. Also now with the the clarification in the Shafi that if you are not in possession of that document, you can very well even prove that to other secondary means of evidence. For example, testimony. So in those situations and scenarios, the other means of proving are also open. So it's not something that you have to mandatorily give the certificate in Section 65B. That's how we would categorize different kinds of evidence which would come along, whether it's a pen drive, other CDs or tape recordings, all of them are admissible. The second leg of the question comes, how do we say this is authentic? That is testing and proving the veracity of that, content of that is different. For that, we look at the general evidence principles which apply.
Yes, ma'am. There is another question. Electronic devices or electronic record is more vulnerable to tampering, alteration, etc. In these circumstances, is it safe to allow prosecution to produce additional electronic evidence, including certificate under Section 65B by way of supplementary charge sheet? It sometimes happens that this certificate or the electronic record itself is not produced along with the first charge sheet. Then it is produced later on. Is it wise to do so given the vulnerabilities of such evidence?
Well, it depends on the facts of a case. As regards production of the certificate, we had very sort of a settle on that regard, that you can even produce evidence. For example, if it's a trial stage and you have not produced or filed it in the first instance, you can cure the defect, later also. That is possible in the trial, but in the appeal it cannot be. There was a case on that also. In the appeal, that may not be possible. In cases of charge sheet, if there is a particular evidence which we have found in the investigation, and there is a clear evidence that electronic evidence to support that, that will go in the charge sheet. Sometimes during the investigation there is a new offense which you feel the facts of the case have attracted, and there is a additional offense which is charged. In those scenarios, you can also lead evidence to prove that, or a charge sheet could be filed with the permission of the court to say that this offense is also attracted, and this is the evidence in support of that. So that is a possibility, but it will really vary upon the facts of every case. What is the final view of the court in such a scenario? Hello.
Yes, this was a question of Mr. Javed Alam. Now there are a few questions from Madam Bala Jyoti. First question is how to detect fraud by banks using OTP.
Fraud by banks. How to detect fraud by banks?
OTP frauds.
Okay. So because the fraud could be through a cyber criminal, a fraud could also be through an insider of a bank. But whatever may be the situation, if a fraud happens through OTP, usually we look at the place, the main modus in such cases would be a social engineering attack. So somebody would have called the owner of the bank account, to share this OTP with him, because the OTP would be coming to a registered phone number of the subscriber. So if the subscriber has himself shared, then obviously there is a bleak chance of getting success on the compensation. But if the person is not liable, supposingly the bank server is hacked or a criminal has taken the OTP from the person, by hacking, for instance, or putting a keylogger, and the person has himself not shared it really, but somehow the criminal has managed to get hold of that, then in that case we'll have to see how we can prove that the person who is victim is not really at fault. It is somebody else who has. So the entire electronic evidence in that regard and the footprint would have to be seen. The bank servers are very helpful in that regard to see what is the IP address which is shown at the time when the transaction also takes place, where the debits also take place. So a lot of these aspects go into investigating such a crime.
There is another question regarding digital signature. How is it procured, and what is the authenticity of digital signature on any document?
Okay, very interesting question. The first part is this, that the controller of certifying authorities is the main head, which is in charge of the giving out or the entire spectrum of the operations of digital signature. The certifying authorities are appointed by the controller and licensed by them to offer digital signatures and issue digital signatures to subscribers. And the certifying authorities, for example, like the TCS, they offer these digital signatures to subscribers and entities. So the technology, the way it works, is PKI based, which is public key encryption based, where there is a private key and a public key, and there's a hash algorithm which is created. So if there is a document, even a full stop or a comma is changed in that document, will change the hash value of that. So therefore, there can be no tampering in case of a digitally signed document. There is no possibility of tampering or interception also. That's how the PKI system or the digital signatures system works, based on hash algorithms and algorithmic formulas.
Right. There is a one question from Ms. Sandeep Kaur. It is regarding electronic evidence and its admissibility in court in terms of section 65B certificate. So who would be the appropriate person to give this certificate? Whether head of the department of a particular department would be the fit person to give the certificate, or who else?
Yes, the person who is the chief technology officer of a organization normally would sign that, because he's overseeing the entire systems of that organization and is responsible for the same. So he is the main officer authorized on the behalf of the company normally to give out and sign any affidavits under section the certificates under section 65B of the Act. So the chief technology officer.
So not necessarily the head of the department, but any person who is looking after the technological part of the company
Yes.
can be the
Usually it is he is the person who is assigned the role by the company to do so.
Right, ma'am. This is the question from Mr. Rajesh Sekri. While allowing all forms of computer output to be admissible in evidence, don't you think the statute has overlooked the risk of manipulation?
Could you repeat the question, Rajuji?
Yes, ma'am. While allowing all forms of computer output to be admissible in evidence, don't you think the statute has overlooked the risk of manipulation?
Yes, I agree to some extent that it's very easy to tamper computer data. So therefore, the risk is always there. And in the world where we are talking about spoofing of IP addresses, and even IMEI numbers or MAC addresses could be spoofed. So it becomes quite a risk to take. But then that's the only way which we can prove is that we prove the authenticity of the data. For the threshold of admissibility, at least they should be admissible, because that is the only way one can prove one's case. But yes, to ensure that the proof is made and the accuracy of the content is established, the principles of law which apply otherwise in evidence will continue to apply even here. So it's not as if you have only crossed the threshold of admissibility, it means that you have dislodged that onus also. So that onus is still to be discharged once the document is admissible. We're only talking about admissibility, so that admissibility merely will not, amount to proving the authenticity.
Right, ma'am. This question is from Miss Tabassum Wani. It is pertaining to jurisdiction partly and one technical issue part also.
Mhm.
Person A is sends notice. A is sent notice by the company terminating him from job. Mail is sent from one state. As it was said that communication gets completed when person receives message and not when he opens. What will be the limitation in case where person was not able to access the mail due to net blockade or some other reasons not able to access the net?
Okay, so the moment the file reaches the designated email ID of the person and its server, it will be deemed receipt. So in that situation, even if he would not have had access, he would not have read, it will be deemed to have been received by him. That is the law. That is what is given in section. So we can actually refer to that particular provision. So the time and place of dispatch and receipt of electronic record is covered by section 13 of our IT Act here. And and if the originator or the addressee has more than one place of business, it will be deemed to be the principal place of business where he has received that document. Even if he is sitting at a branch office, it is like a deemed receipt principle that we apply in such a scenario. So that's how, it would be at least assumed that he has got the document. He may not have read it, is another aspect of the story. He may have to prove that. But he'll be liable for, at least on that account, that he cannot say that I have not received the document. So the limitation, as regards your question was on limitation will continue to, apply in such a case And he cannot say that I did not see it in time, and somehow this problem happened. Maybe condoned is another aspect under Section 5, but then the limitation law will go on. You may have to seek the condonation.
Actually, this question is in another context also, because in this part of country we have net blockade for many days. We have some events. So in that case, we for days together we don't receive emails, we don't receive WhatsApp messages. So maybe that issue arises. What would be whether it could be deemed that it has been received, despite of the fact that there was no internet access to reach the.
Yes. So the point here is in Section 13(2) of the IT Act, because it says that save as otherwise agreed between the originator and the addressee. The time of receipt of the electronic record will be determined as follows. And then it says if the addressee has designated a computer resource for the purpose of receiving electronic records. I'm sure in the courts here, J&K also have designated one address where they can file a complaint, or there would be a registry office. In case they are not able to physically file, there would be some mechanism of electronically filing their papers or their application. In that case, the receipt occurs at the time when the electronic record enters the designated computer resource. So it means that at that point, the receipt has occurred the moment it reaches the server, even if you've not been able to retrieve that information. That is a correct interpretation of IT Act at least. And only if the electronic record is sent to another email address, which is not the designated one, then the receipt is deemed to occur when the electronic record is retrieved by the addressee. That is when he actually reads it. So if it is coming to a designated email ID, my view is again the same. I reform what I'm saying, that this will be deemed to be received by the court registry, and the limitation, we'll have to look at it from that perspective.
There is another question from Ms. Sandeep Kaur. Nowadays, there is rise in offences of data theft. Subscribers, sometimes subscribers are aware, sometimes they are not aware. What is the remedy available to such subscriber whose data is stolen if he comes to know about it later on?
Okay, if the subscriber comes to know later on, the moment he comes to know, he needs to inform the police. And as regards his own measures, he should not have been negligent in compromising the data himself, sharing the data, for example. But if it's been hacked, he can always say I had no information that this has happened, and he's in fact a victim of hacking. Apart from maybe monies are siphoned off from his account, or whatever data may have been stolen from his account. So he's in a way a victim of cybercrime. So he can obviously prove that he has made entire prudence to preserve his data in the right manner by putting the right tools and software on his system. Yet if something has happened, then he can at least go for a redressal of legal recourse in that.
Apart from the criminal liability, does the person also have the civil liability? To what extent this civil liability can go?
See, if it is, there are two scenarios which are possible. One is, what data has he lost? Is it official data or is it personal data? Now, if it is official data, certainly he is bound to comply with all the office IT policy norms. If they are asked to use DLP, the VPN, the virtual private network, and he doesn't use that, and he exposes official data, in that regard, he should be negligent, and he can be sued for damages under Section 83 also, because he's been negligent, and somehow the loss has occurred because of his I would say inaction or omission. So that is another one scenario. Other scenarios when there is a personal information which is at stake, a personal information which he may have lost by some hacking activity or somebody. Then if it's valuable data, he can very well sue for compensation because the other person has unauthorizedly accessed and copied his data. Again, under Section 43, he can, have that redressal for compensation. Criminal remedies are definitely there, but civil liability, you can ask for compensation. That regard. Yes. Ajit, is another question?
Yes, ma'am. This is question from our trainee officer, Miss Bazila Bashir. She says, don't you think that the law laid down in Shafi Muhammad case of 2018 is per incurium, as the Supreme Court had earlier decided the case, and this case overlooks PV Anwar's case of 2014. What is your take on it?
See, I feel that in PV Anwar's case, they said that it is mandatory to have that 65B score certificate. And in Shafi Muhammad, they have said that basically in such cases where you're not in possession of that electronic record or data, you cannot possibly give the certificate. So in those situations, you can have other means of proving evidence, secondary means of proving evidence. In the latest, case where it has been referred to a three-judge bench, in this Pandit's case, that case again, what is the issue is going to be review of. They will probably look at now the Shafi Muhammad case, whether this exactly gives the right principle, or should there be another view on this electronic evidence issue. I felt that since the Anwar versus Bashir judgment also was like the judge mentioned now, it requires maybe a 5-judge bench to look at both the judgments together and see what should be the correct law of the land, because it has created some ripples and some confusion on this front. Until it is brought to a certainty, this gray area will remain at this point. So we are hoping that law will change and law will be more clear with the new case deciding these two earlier cases, giving some I would say coherence to the entire subject of electronic evidence and where we stand today.
Great. Ma'am, could you throw light on the reference to the larger bench? Is it related to seeing whether Shafi Muhammad is correct, or it would also open PV Anwar case itself?
Whatever I've read about this judgment, and I've seen and extensively looked at this, it basically looks into this Shafi Muhammad case, whether the verdict there is correct or not. Should it be changed? The law should be changed. The window of Anwar versus Bashir as a reference may not be very clearly there, but in this scenario, it should have been, because and that case, if you have to decide that case, then 5-judge bench should be the ideal bench, because both being 3-judge bench will not be able to decide this issue and overrule that judgment. That may not be possible.
Right, ma'am. Right, ma'am. Very right. Now, this is a question from Mr. Mayank Gupta. How the artificial intelligence can affect cyber security?
How it can affect cyber security. I was speaking at one of the events, for data scientists in Pune at the Stanford WITS conference this year, and we were addressing a lot of data scientists who are coming from across, India, talking only about what are the data ethics in cybersecurity and data ethics in data science now. With the evolving, IT as a law, as a subject, the programmers, the data miners, the coders, the software developers, they are all looking at data ethics in the sense that analytics, and when you're doing AI, it should be programmed in such a way that it adheres to the privacy and data protection norms. So when AI is changing the dimensions of cybersecurity, developers are making new programs and technologies. They should be well versed with the data ethics principles also. And while they use AI, we have started using AI also in courts, and we are talking about virtual courts today, and we're talking about even in US and UK, China, they are using all even robotic courts. Online dispute resolutions are happening. So AI has a huge role that it will play, even in the access to justice or the justice delivery systems will change with AI. You can have robotic, courts. You can have for small challans, traffic challans, and other things. Some of the pilot projects are already underway, and even in the Supreme Court of India, we have had one experiment like that in the last year. So there is a pilot project of that kind. So that's a very interesting, way to go. How virtual, say AI will change the entire judiciary, the way it works. The judicial system will change with AI, and it'll be maybe more fast in terms of adjudication of smaller claims, at least, if not the bigger questions of law, which obviously with judges only it's possible. The judges only decide those tricky issues of law and evidence that we're talking about. But yes, small matters can probably be looked into through AI also. We can.
Yes, ma'am. This is a question from Mr. Iqbal Akhund. He says, in terms of Section 94 CRPC, an application is moved for getting the document. Obviously, he's referring to electronic record. So, if the person who is directed to produce the document, he says that I have destroyed it. So, how then this electronic record be procured, or how it can be proved then?
Okay, so if it is electronic record, there is always a footprint, first of all. So if he has destroyed it, it could be on his machine. There are recovery softwares possible to even find out what was deleted. And the hard disk is such a gadget that unless there is a zero level formatting, layer after layer after layer, you will still be able to recover data. So that is one thing. Second option possible is that if supposingly you don't have the hard disk itself, maybe that machine is not there with you, then what do you do? There are footprints in the sense that if it is, for example, a post on a social media platform or an email which came to you, the service provider might have some footprint, some data of the same. So one can approach them and maybe bring them as a witness in the case to depose that yes, this mail at this particular time came, and this is the they can produce it in a sealed envelope, maybe that particular page which was objectionable. Then very interestingly, there are some tools available on the net. I was showing you the Wayback Time Machine. If somebody has deleted that post, which you find that you want to have a case against the service provider who has posted that, you go back to the Wayback Machine and actually check what the page looked like 2 years ago or 1 year ago or 6 months ago. You can retrieve the data. So data retrieval is something which is not difficult in today's world. We can still recover a lot of data. It is the hard copy which can get destroyed, and if that original goes away, it might be a difficult proposition to get to prove that.
So I think data forensic would come into picture then, to
Yes,
get
absolutely.
data even if it is destroyed.
Absolutely.
This is a question from Ms. Farika Nazir. She says, a digital signature on any order or judgment, would it make it as certified copy for the purpose of admissibility?
Digital signature on any certified copy judgment.
Any order or judgment which we are uploading on the websites.
Absolutely. It has the credibility. Absolutely, there is a complete authenticity, and the law protects such documents and presumes them that there's a presumption that this is correct, and it is the best way of signing documents. So I think that's the safest approach to take, and the best approach.
This is a question from Mr. Tabriz Ahmed. He says, rather, answer is in the question itself. Says the hash value of the electronic record changes when the evidence is again taken from present or copied device. Then how the evidence in electronic form will be taken up for consideration when the original electronic record presented in the charge sheet got destroyed?
Okay. So at the time when the forensics is done, there is a data drive from where this is copied, and there is a imaged hard drive where it is copied, like a clone created for the same. So when that happens, we use a write blocker so that the original hard disk, there is no disruption or tampering of the same. And when the image is copied, there is a hash value which is created. That hash value always matches with the image to disk. So there is a complete match of the same, and that is what proves that this hard disk has not been tampered and the image file is correct version of the earlier version, original version. So your question was, if that earlier version got damaged, then how do we prove that the second version, that is the imaged file, the document is correct?
Original is destroyed, and this electronic record is available with hash value. So when it is copied, would the hash value change?
So
And
it depends if the original was with the police authorities or with the in the custody of the court, or the local commissioner may have taken it and given it in the custody of the court. It depends. If it is not with the court, obviously it could be tampered or destroyed if it's in the public, I would say space where the private party has access to it. At that point of time, if there was a report generated of a forensic expert, a lab, a computer a forensic lab, that will have weight, because that will say that this was the original hard disk hash value, and this is matching exactly with the imaged hard disk value. So that should be a good source of proving the authenticity, that at that point it was not tampered, and this was the examination done of the on the hard disk, and these were the evidences which were found. So it will have some weight. The certificate or given by the forensic lab, the particular analysis done by the lab, the report will have
just to, I want to add to it that any data copied from the original would carry same hash value, and the copy made from such copy would also carry the same hash value if there is no change taken place in between. So am I right in saying so, ma'am?
if there is a hash value generated and the document is not the tampered, and the data remains the same, then there would be a same hash value. But if the data changes, then it could be a different hash value.
Mere copying of the data would not change the hash value.
Hmm. Because if it does, then what is the sanctity left of the hash value?
Right, ma'am, right. So this is a question from Mr. Siddhant Vaid. He says, what is the offense committed by the fraudster by sending fraud link?
By sending fraud link.
Fraud link. There are links with.
The question is, what is the
offense committed if such thing happens?
If he sends a fake link, a link. If he sends a malware, for example, again section 43 read with 66, if it is meant for hacking purposes, if the intention is to hack, for example, he will be liable under section 66 of the IT Act. And it depends why this link was sent, the purpose, the malintention or the knowledge also of the person, and the purpose behind it. If it is supposed to be done for damaging somebody's system, or is it only to infect a system with virus. Usually 43 read with 66 of IT Act comes into play in such cases.
This is a question from Mr. Nasir Madar. How can one reveal identity of phone caller made through internet or by some app by any person using phone number of somebody else?
How do you find out the identity of a person?
How to get the identity of a caller who makes a call on somebody else's phone number through internet phone or
VoIP. A lot of times this is a rampant problem. I agree. A lot of times VoIP platforms are used to make phishing calls, and usually you see a lot of things go into it. When there is a CDR taken or the tower signals are checked, whether it has been made through VoIP will also reflect on the footprint. how this call was made. And if the platform's name is there, then even law enforcement can ask the platform to share the details. But most often criminals follow a very circuitous route and onion routing, as I explained. And it's very difficult because they may have accessed that platform also through Tor. So if they access it through Tor, they have placed a hiding of the IP at the first level itself when the Tor is there. And then when they go to a proxy server or they grab on an identity, and then they go to a view IP, there's a duplication on duplication of IP addresses which are changed in terms of spoofing. So it becomes very difficult to trace in such scenarios. But nevertheless, there have been times when tracing is possible. A lot of different evidences are taken into account, including the CDR and the tower signal and the data, the metadata which comes along, with the call, timestamp and other things which come along with the call.
Right. This is a question from Mr. Majid Farooq. He says, in cyber crimes, can the accused be convicted solely on the basis of electronic evidence, though not corroborated by direct evidence of the complainant or other witnesses?
It can be, provided the evidence which is led has been proven properly. Because if we don't do that, then we don't. Then it will be, not implementing the intent of the provisions of IT Act in the proper spirit. Because the IT Act itself gives legal recognition to electronic records. The evidence law has been amended. So as long as the evidence is admissible and has been proven as per the prescribed principles of law of evidence, then there shouldn't be any bar that just because this is an electronic evidence proven case, there shouldn't be a conviction in the case. So I feel that we should be giving the same, sanctity to both electronic documents and hard documents.
This question is from Mr. Feroz Khan. He says, receiving of electronic evidence through WhatsApp or other such platforms, if permissible, how to determine its authenticity?
Okay, so through WhatsApp or other platforms. Now, WhatsApp specifically has an encryption, end-to-end encryption, and they may not have access to the content which is floating on their platform. But they do know who's the account holder, the admin, and what point of time the particular message has gone. So, if there's a case where certain information like this is needed, then the law enforcement or the courts can direct the authorities, the service provider, to give information of the creator of that particular account, or the admin or the member of that account, and what messages have gone and what time it is. It is a different matter that whether the content which is also gone inside it can be testified or can be put on a certificate by the service provider, the social media platform. But certainly the timestamps and all and the account things can be verified from them.
Right. This question is from Mr. Ashok Shawan. He says, in bank recovery cases, it is often seen that only a certificate issued electronically is annexed. So, what is the authenticity of this? Doesn't it require a signature to be put on the certificate? Actually, I think it is in respect of Banking Evidence Act partly covering that. So where it is required that certificate is given by the manager of the bank. He gives certificate electronically by putting his electronic signature. Would it have authenticity as the signature itself?
Absolutely. That's what electronic signatures are considered valid. And if it is, especially if it is a digital signature, then this document is legally recognized and a secure electronic record as per the IT Act. So there is no issue to such a document at all. I mean, legally, it is a sound document.
This is last question. If somebody's phone is used by someone else to do any kind of crime, and he has deleted any kind of action, but when investigation is initiated and the person is caught, the person claims that also been So how it will be approached, as he cannot prove that the device was used by someone else. So the question essentially pertains to somebody else using somebody's device and after committing the offense, deleting the data. And the
Mm.
person whose device it is, he is caught and he is
Mm.
unaware that this phone was ever used by somebody. So
Yes.
how to get over it?
Yes. Okay. In this regard, there is a provision in the IT Act that if somebody has, sent an electronic message, then the attribution is to the originator. If it was sent by the originator himself or by a person who had the authority to do that. Now, if a particular mail has been sent, it means that it has come from that particular account, but it necessarily doesn't have a presumption that the owner of the phone only would have sent it. Now, the actual person who is sending it, it has come from that phone X, but the originator is that phone X, not really the person who's using it. It's very interesting, principle which is highlighted. I'll just try to read this particular provision if I can just immediately get hold of this.
Uh, I would also add to it
Yeah,
that
yeah.
uh, in
Also,
this kind of
identity theft.
situation, the only thing which can be proved is that this device was used to commit offense. But
Hmm, absolutely.
using this device, it has also to be proved, or rather,
Yes.
it is to be presumed. Then the person gets a chance to rebut it that this was not me who was using this device.
Yes. So he will not be implicated of this crime, but the phone that it has gone from there, that will be there. Even read section 1112 of the IT Act. In that will make the picture very clear. But the principle, what I'm saying is by and large this only there. So that is one aspect. Who is the originator, and the particular phone or that particular email will not be attributed to uh, the person who's sending really, but the machine, the device will be. And second is the fact of identity theft, that he will be charged of identity theft, the other person who's actually sent it. Now, how that can be proved is another, again another part of, we normally use forensics to do that. If supposingly he has misused the phone during that time when he has left it, there may be other windows which he have opened. Maybe he has accessed his email also on it or some other thing. So with the help of that also sometimes corroborative evidence can be led, in that regard. So that's how investigations occur in all these matters, identity theft and other matters.
Ma'am, in a minute, I'll check. Just probably Chief Justice would also join again.
Surely,
I'll
surely,
just
a pleasure. If anyone has any other question, I'll be very happy to answer. Especially during COVID times, there are a lot of crimes, as I was explaining, and a lot of times people report, and sometimes they may not report. If they don't report, is another aspect. But if there is a reporting and there is a case which is filed in the courts, uh, a number of times they don't save electronic evidence, and we tell them that if somebody is a victim, first thing you have to do is just take a screenshot, at least have some details of the same, so that you can prove that, because without that then it will be very difficult to get hold of evidence. Rajivji, do we have Honorable Justice
just
Geeta
just
Mittal join?
just confirming, ma'am. Uh, just getting message in a minute or so.
Surely.
So, meanwhile, we can just talk about what what have been the changes which this pandemic had have brought to the whole cyber scenario.
Yes, I think right now the scenario is this, that the schools, for example, they are grappling with which platform to use. And there are new policies being made. We've been making IT policy, social media policy of various institutions, advising them what is to be done. For example, there is a technique called data loss prevention software. Many companies had not deployed that. It helps trigger data loss possibilities. For example, an employee is working from home and he's using a system and which is not authorized, or if he uses the unauthorized system and does unauthorized activity like forwards those mails which are crucial to outsiders of the organization. So there's a DLP software which is deployed in such scenarios. And if the company has not done that, then there could be loss of data. So there are new changes in the cybersecurity domain. People were not taking cybersecurity so seriously, have begun to take it more seriously, and that helps because then obviously you get more evidence to say that this has happened or X particular situation has occurred, and then one will be able to prove. Otherwise, during this lockdown, it is very difficult to get the right evidence, even if the company realizes later on that data was lost during COVID lockdown when this employee were home. How does one go about proving? So that's the reason why companies have started deploying more and more mechanisms to check, data loss, and secure systems are being put in, place by the company. That's how schools, businesses, individuals, they are beginning to be more cautious of the fake links, fake donation sites, and other kind of possible sources of committing cyber crimes, which people, criminals use. So we are all spreading awareness during this time, and that's the need of the hour. Apart from the mental well-being of people, because everybody going through a crisis time and transition post lockdown period. There will be probably rise in cybercrime cases even later, and even general litigation will increase. That's the sentiment, I think. A lot of force majeure clauses being discussed these days, whether the contracts are broken. They will be suing, people who are not paying based on those contracts. Increase in litigation will occur. That's what we are looking at. And during these times when people are contracting online, we're telling them use digital signatures, use electronic signatures, because if you're e-contracting, tomorrow the party should not be able to say, okay, there was no contract. So therefore, in today's times, when we are almost going across COVID times, electronic footprint is very important. So whatever is happening, documenting that, whether it's using digital signatures or otherwise, is very, very essential to safeguard your rights. That's what we're telling every individual.
Yes, ma'am. I'll tell my participants over here that Dr. Karnika Seth is consultant with the government of India and other governments also in many of the cyber security related and cyber issue related projects of the governments. So in that context, I would like to know from you, so hasn't the time come when we should start the conversation about cyber security from the very beginning, from the primary classes itself, because the children are very wise. They start using these smartphones when they are just 1 hour so old. So
Absolutely.
start from that very stage that cyber security issues can be discussed and conversation goes on in schools also, so that we don't totally become dependent on the government for cyber security.
Very right, sir. Because when there's currently the cybersecurity policy of your country is also being shaped, and I was fortunate to be a part of the deliberation there when we discussed that the cybersecurity policy should also inculcate the children's security, because they are maximum, using the information technology for education or otherwise today, and it's pertinent to do that. At the level of NCRT also, I'm trying to voice our concern that they should have a new curriculum for educating them on do's and don'ts of internet. And I have in fact started an organization called FIRE, where Foundation for Institutional Reform and Education, where we're doing across India trainings to various stakeholders on this issue of cyber awareness. So policy making is a huge role. We are trying to build strength into this whole ecosystem by trainings, law enforcement, schools, children, educational institutions, and at the government level, working to combating problems like fake news. So we've done a lot of work in terms of that as well. And I'm hoping that with this post-COVID period, there will be new rules, even in the judicial system. We are hoping we'll get new rules on electronic evidence soon, and a lot of things are in the pipeline. I'm sure have been accelerated due to this COVID time, and because the need is increased, the need to have electronic access even to justice, delivery system, and the judicial system is now paramount. So we are working on this strengthening cyber law across various paradigms, whether it's policy making or it's awareness or it's practice of law or even writing, authoring, whatever we can do our best possible contribution we can make, trying to do that.
Thank you. Thank you very much, Dr. Karnika. I am told that Honorable the Chief Justice is still hearing the matter.
Okay.
Very, very prime importance. So she has not been able to get out of that matter soon. So we'll close here. And I must thank you from core of my heart that you have guided us through in this very, very important program. And especially in these days when cyber crimes are on rise, which is recognized world over. So your guidance to our officer would be of immense help. And these matters are surely coming in the court in near future. So we'll be able to deal with those matters effectively by your what you have guided us. Thank you very much from on behalf of Judicial Academy and on behalf of all the judicial officers who have participated. Thank you for sparing your time and giving us this valuable insight into this program. And thank you very much.
Thank you so much. I thank the J&K Academy and Honorable Justice Mittal, Rajiv J for giving me this opportunity, and all of you who have had the patience to hear. This subject is vast and there's so much to tell. In the whatever little time that I could possibly explain, I've tried to share my views. And any opportunity, any kind of queries are welcome, and you may feel free to write to me anytime. I think Rajiv ji will share the email address also in case there's any query or anything which I can help you with at any point of time on the subject. I'll be very grateful and happy to do that.
Thank you. And with your permission, we'll share this presentation to our participants.
Surely,
and
surely.
We also share this video recording with the participants. This would be available on our website also. And this can be shared on your personal blog also. We'll permit to do that immediately after this. You can have this from us and you can post it on your website also so that the information goes to all and everybody is benefited. So thank you very much. Thank you all the participants for your curious questions also and your patient deliberations in this webinar. Thank you very much, and see you tomorrow in another very important webinar on some different aspect. So with this, I'll close the webinar. Thanks once again to everybody and to Dr. Seth also. Thank you very much.